not stated anywhere. So those are issues that need to be addressed by the law. Then there is also the new issue of magistrates who are now handling labor matters. It means that for a while there will be instability as the magistrates are on a learning curve, and it takes a while before they get to understand the issues. It means that when you go before a magistrate, you have a heavier burden because you have to explain to the magistrate who has perhaps never handled any labor matter how this is done, because otherwise they will decide it the way they decide all other matters. We have had complaints, for example, that magistrates are using the Civil Procedure Act instead of the Employment and Labor Relations Code procedure rules to handle employment matters. Again, if you appear before them and you yourself do not know the difference, then of course they will decide the way they understand. Recently, there is the case of Weber, a big issue. There is the decision of the Supreme Court, which everybody is trying to understand. People are asking, does it affect matters which happened before the decision of the Supreme Court? Does it affect matters which happened before the decision of the Court of Appeal? Does it affect matters which happened between the time Justice Ojwang made the decision up to the time that the Court of Appeal made its decision? Again, those are issues that will bring a bit of discomfort before the matter settles. The other issues about this impression, this perception that courts are more friendly to workers than to employers. If I can start with the issue of costs, I am one of those who rarely give costs against an employee. But I know it as a fact that most of the employees are not capable of paying. He's lost his job, he's come to court, and his case has been thrown out. Even if we gave you costs, would you be able to get it? You'd just be chasing the wind. So we are realistic, and a lot of times we do not bother to give costs. But a few times we do. And especially against unions, we make decisions for costs. But again, if you look at the employment relationship, if you look at the Employment Act, the employer is the one who has obligations. It's not like the old Employment Act, which was repealed. Look at it from the very beginning to the end. It is the employer who has obligations. There is very little obligation from the employee, which means that when a matter comes to court, we will only be looking at the employer. Did the employer comply with what the law provides? Because there is nothing for the employee to do. The law only says what the employee has to prove is that they were unfairly terminated. Then it is now the employer who must prove that the termination was fair. And if you don't prove, then we will decide against you. But there are if you look at all the cases that come to court, about maybe 1/3 are lost. The employee loses them. The other 2/3, the employer loses. A lot of times the employer loses not because they don't have a good case, but because of the way they either handled the matter or the way they presented the case in court. A lot of employers do not look at just Section 41 and Section 43 of the Employment Act. If you observe those ones, we will not even say that your decision was harsh, because that's a discretion. The Employment Act, Section 44 says, if there is gross misconduct, then there is the liability for dismissal. That is on the part of the employee. Again, a lot of employers, when they come, even the lawyers from employers, all you concentrate on is telling us the employee was wrong or the employee was, or the employer was right. Nobody ever tells us about the others. For example, you don't tell us, don't reinstate because of A, B, C, D. You don't tell us, don't give compensation of 12 months because of A, B, C, D. So you leave it to the court to decide how to deal with the matter. A lot of employers will not even tell you, will not even touch what the employee is asking for. For example, the employee may have asked about it, may have asked for issues, so that the employer will only look at the liability. Was the employment right, or even if he loses the case, he will be entitled to the leave. If he's entitled to, I mean, if he was underpaid, even if he loses the case, he will be entitled to the underpayments. So sometimes the employee loses the case on the unfair termination. So that is perhaps why sometimes employers think we are unfair. But the employer has to always address all the issues. Then again, there is the issue about the decisions, different decisions from different courts, which now even includes the Court of Appeal. Sometimes the Court of Appeal looks at our decisions. One bench decides one way, another bench decides another way. And therefore, as an employer, you do not know how to advise your, I mean, as FKE or as employers, you do not know how to advise your organization on what to do because of decisions which might appear to be conflict. All these conflicting decisions are brought up every time you are addressing the court, and the court is alive to them. A situation will arise when there will be a settling of the position, and then parties can be certain about the issues so that they can advise their people appropriately. Have I answered everything? I think I've addressed most of the issues that were raised. If that is the case, then I think I will now wait for to respond to specific questions. Thank you.
Thank you, Justice. Can we just once again appreciate the Justice? I think she has done justice. The judge has given us an opportunity to respond to a few specific questions. And because there are a few specific questions, we are only going to give very limited allowance to the floor. Perhaps we just go by row. We just have one person on that row, then one on this row, one on this row, and one on this row, so that then we are fair to all the columns. Now, let's just see. Okay, let's see from that row how many will have questions. The other side. Okay, one. Okay, this side. The next. Two. The next. Three. This row. Question. Good. We have three questions. Let's make them very brief. Be direct and very brief, specific, and thank you. Let's start from. Okay. Let's start from there. Your name. Your name.
My name is Helen Joke from the Cooperative University. Thank you, Justice Maureen, for your insights. I would like to seek a clarification on one thing. When universities are negotiating, we normally consult the SRC, and they write letters to us asking us to negotiate items that do not have financial obligations. And when you look at the items